Thank you. There may not agree there will be fairness. What we can try to do, I guess, from the government's perspective, is to make sure that there is justice. However, no. You'll use up my time. We need to strive in order to get justice. And I do agree that at the beginning of the day that everyone should be held accountable for executing their own due diligence in their investments, right? And part of that due diligence, as Professor Coffey would say, changes from who you are. If you're the proverbial little old lady at one level, conversely, the union official who might have more resources than the little old lady would be at a slightly different level, to a fund of some sort or an association somewhere in between of those. So the level of due diligence is going to be vary, but we do expect in this country that everyone exercises due diligence. And to the extent then that due diligence doesn't work out as far as investments going up and down, that is your responsibility. Added to that, however, is when that due diligence is in reliance on the government in certain areas, then that is a responsibility of the government to come forward. So when you do your due diligence, Ms. Chapman saying, looking into the SEC, has the SEC done their job? Well, you are appropriately relying on the SEC to do their job. And when you look to, that's before the fact, right? And after the fact, you should be able to look to SIPC to do their job because they are quasi-government entities. See, this is the whole issue, and let's say this for 30 seconds, that we're doing. There's a bill on the floor this week, today and tomorrow, which in essence does what occurred here. It creates what I'll call a moral hazard, if you will, by relying on the government, as you did, because the government says, we're going to protect you with the SEC. And so you have a right then to rely on that. Maybe you would have done more due diligence if it wasn't out there, but we told you you can rely on it. So you did, and that's right, you should. Also, we set up the SIPC and said you can rely on it, and you did. Had we never set those things up, you may have made other investments or made other decisions. But because we set those entities up, now we've created a different investment strategy or a decision is what we call moral hazard. And the bill that we're going to be voting on, just for your information, today and tomorrow, expands those involvements or intrusions or activities by the government. So you'll in the future maybe even say, I can be more reliant on the government and less due diligence, which I think is not a good thing. For example, one of the comments from one of the people that I entered into the record said, with regard to clawbacks, and let's do a quick hands if I understood the testimony. Everyone, except for Mr. Coffey on this panel, believes that we should not have clawbacks. Is that correct? If you're in favor of clawbacks, potentially in any one shape, form, or another, is Mr. Coffey. Okay, and I understand that. But one of the testimonies was, or the letter that I entered into record from a gentle lady from Bergenfield said, indeed, any clawbacks, if we're going to have them, should begin with the SEC and clawing back from the SEC because you were in reliance upon them, and maybe we should be clawing back from them. And that's why I gave my opening comments that we're not asking much from them in the bill that's passing tomorrow. In fact, we're doubling their salary and their appropriations and their authorization and saying, hopefully in the future you'll make some changes, but we're going to increase it. So you might just want to take a look at what's coming down on the floor tomorrow and today, because we're really not asking for those things, what I think we should be. We should be holding them accountable for what they did wrong in the past and holding the people particularly accountable for the failures that they made. And before we give them any more money, we should be making sure that they make some changes. Now, Ms. Chapman, you said, just to get into the weeds on one not a little point, but one point in some of the material you supplied us with, you said that the trustee, correct me if I'm wrong, the trustee and SIPC are running administrative expenses of approximately $100 million per year. But Mr. Harbeck says in his testimony that the trustees have only paid $1.2 million so far. Can you
I think I can explain
clarify that? Yeah.
Yes, the trustees' legal fees are...
Hit your little button.
I'm sorry. The trustees' legal fees have been approved for the first 15 weeks at the rate of $1 million a week. He then filed an application for another 23 weeks, and he's running again at $1 million a week. So if you project that for a year, it would be $50 million a year. And Mr. Harbeck has said publicly that the non-legal fees, the forensic accountants, et cetera, who are going back through generations to figure out the net investment, which of course is not required by the statute, Mr. Harbeck had said in the press that those expenses are running at the rate of $1 million a week.
Wow. So it's one of those cases, as is typical, and I see my time has come up already, cases where there's almost an incentive for, and I'm not saying that there is, I'm just saying on the face of it, there's an incentive for not things to move at an expedited basis because you have a pretty good fee there that's guaranteed to be paid for the period of time.
There's an inherent conflict of interest in the way the statute is set up.
And if I can I just want to make one statement that we, some of these aspects may have impacts upon getting more fees in, may have impacts upon broker-dealers, of course, right? And we did suggest to SIFMA that they might want to come and testify or at least be at the hearing today. They declined to do so. So we would certainly like to hear from them at some point in time what they see as the impact, because if we want to do, and I think I'm on board with where most of you are, and Mr. Coffey, I understand if we want to go where you need to do on close on this, we really have to be real tight in that language, because what you don't want to do is to come up with language that, and I'm a lawyer too, has any wiggle room in it, that then you put somebody here on the spot that they even have to go out and go to the aggravation of hiring a lawyer where they really shouldn't have to go through that aggravation. And I think you probably would agree that you're going to be able to draw that line clear enough so that they would not just have mass lawsuits under this thing that would just be very targeted. I would think that that target would be very, very limited as to ones that the government has any evidence whatsoever on that there is or even was potential for collusion, whether it's family members or other business associates or something like that. Is that where you were going on that? Not the charitable organization, well, maybe the charitable, but just for any of the other lawsuits that they would potential. Hit your button, thanks. Button.
I think you could move from the current good faith defense, which is based on a reasonable person, to more of a recklessness standard that would make it somewhat harder to recover under a fraudulent conveyance statute.
Yeah, you just don't want an overly zealous specific there going after saying, well, now we have a reckless standard and we're going to still go after people that.
I understand.
Because I know how prosecutors.
I just remembered that Mr. Picard is suing on behalf of small investors. There's no villain here. This is a zero-sum game between some large investors and the smaller investors, and I hope he's able to recover a good deal from some of those larger investors to benefit the smaller investors.
But remember, some of those are not villains. I would assume the vast majority of them are not villains either, right?
They could have been reckless, however.
They could have been reckless. But if they're not villains, then you have to make that case, and we don't want to have the other people be swept into that and incur the expense and aggravation.
Right now, if you're simply negligent, you don't get the good faith defense.
I agree with you on that.